Welcome to Navigating Receiverships, a podcast from the Commercial Receivers Association, focused on building a better understanding of what brings companies into receivership, what happens in receivership, what makes them unique, some alternatives to receiverships, and ultimately, what happens to the business as the receivership is closed out. I'm one of your hosts, Eric Morcheski, CRA board member and CEO of Nimble Strategies. I'm here today with Mark Owens, partner of the Restructuring and Bankruptcy Department Chair and Motorsports Practice Chair for Barnes and Thornburg, working out of a number of offices for Barnes and Thornburg, DC, Indianapolis, Wilmington, Delaware, and maybe coming to a city near you any day now. Mark, thank you so much for joining us. Can you tell our listeners a little bit about yourself and your background?
Sure, and I'm happy to. Been practicing restructuring and bankruptcy law about 26 or so years now. Spent a year as a federal bankruptcy clerk a long time ago. Been here at Barnes and Thornburg. This is my 21st year. As you mentioned, I chair the restructuring and bankruptcy group and have been a part of that since the beginning. And, since about 2000, late 2007, early 2008, have been involved in many, few hundred receiverships based some on the plaintiff slash lender slash servicer side and more on representing the receiver side. So happy to be here.
Yeah, and tell us a little bit for those of our listeners that maybe don't know Barnes and Thornburg as well. Tell us a little bit about Barnes and Thornburg.
Sure. So Barnes and Thornburg is a national firm, AmLaw 100 firm in the United States. I think we're at about 26 offices now. We keep adding, right around 900 or so, lawyers slash professionals from east to west, north to south, San Diego, LA, New York, Delaware, Philly, Jersey, DC, Atlanta, Florida, etc. So a full service firm throughout the US.
Yeah. So let's dive in a little bit. So today we're going to be talking about senior care receivership. Um, Give us a little bit of a background on this senior care facility or facilities.
Sure. So I was counsel to the receiver in the case. It was 14 senior living centers in the Pacific Northwest, specifically Oregon. There was kind of a quasi companion case with five senior living facilities in Washington State as well. But we'll focus on kind of the 14 senior living facility. Most, if not all of them, where I would say were in more rural areas, not really in cities, which, those in the CRA or who are listening to this, probably who have been involved in these cases would probably understand that sometimes there's different challenges with that as well.
Yeah, and so what were kind of some of the factors that led this entity into receivership, these 14 facilities?
Pretty much the usual, right? The senior secured lender. This was part of a CMBS pool that was kicked out into special, and foreclosure was appointed. Receiver was appointed. I was not originally brought on as counsel in the very beginning, and then I got brought on as counsel a little bit later when kind of the things were ramping up and the decision was made to start proceeding to a marketing and sale process.
Okay. So you mentioned you were brought in more on that marketing and sale process. What was happening in the receivership when you were being brought in?
Sure. So, and it was fairly soon after the appointment. It just wasn't, I didn't review the order ahead of time. A lot of times, when I work with a lot of my receiver clients, to the extent possible, I try to review the proposed order because just, as anybody in our industry, there's a lot of things you learn over, the years of doing this. And sometimes I kind of try to follow the philosophy that, receiver orders, grow, they're organic, things change, and to the extent we can use our collective experience to, request certain provisions from a court, it really makes it flow easier. It makes it less expensive because you're not going to court for a lot of things. And listen, in distress situations, as we all know, being efficient and effective is really important. So, when I was first brought in, it was more along the lines of, okay, understanding what the assets were and where they were. Certainly as licensed facilities, the receiver was not, operating them himself. the management that was there was not related to the owner or borrower, and stayed on, as the licensed operators, or the, opco, because a lot of these are split between opcos and propcos. The
Mm-hmm.
propco owns the dirt slash improvements. The opco runs it. Sometimes there's a master lease as well, depending on the size of the portfolio. So it was kind of getting our arms around that. But then, the first issue that we had in the case was, we had an issue with insurance. So, insurance a lot of times is, it needs to be renewed on a yearly basis. And in these types of facilities, you have your core insurance. And I'll preface this, I am not an insurance lawyer, and I worked with a lot of my insurance colleagues on this. But also tail policies are very important because, sometimes things occur at facilities, but maybe they're not known, or suit is not brought till later. Thus, the tail policy is important for value and also sale. So in this case, when that was going to be renewed, the insurance company kind of took a position and said, well, wait a second, the owner slash borrower that we insured is no longer operating these facilities, and therefore we're calling a change in control under the policy. So now you have to really do a new policy. We have to do a new binder. And because that this is now in receivership and it's a receiver who's appointed, your premium is basically going to go up. And going up was a lot,
This wasn't just
multiple
a
millions
general
of
liability
dollars.
policy for a professional services firm like mine, or something, right? This is 14 facilities overseeing a number of patients in senior care. It
Yes,
starts at a lot and it only goes up to more.
it goes up to more. And it was about, my recollection was about $2 million more.
Yeah.
So, kind of looking at that, and you have some back and forth, and the insurance company was not budging. So, then we had to look at a strategy. And luckily, Oregon has, in my opinion, a pretty robust statute for receiverships, which is nice, like in Missouri, where you are, Eric, as well. I don't know if it's officially Eucrea State, but it's similar.
Mhm.
Okay. And we kind of looked at it, and it's like, well, wait a second. Do you fight a change in control? And legally, when you're thinking about these processes, okay, change in control, and as soon as you start to think facts in anybody who's been involved in litigation, you start to hear facts. It takes time, it takes expense. You probably don't get out on a summary judgment. You're dealing with evidence and things like that. And then the other thing that we kind of looked at was, well, wait a second. Clearly, in our opinion at least, right? Clearly, my litigation hat's coming on. This insurance is a contract, that was in existence at the time of the receivership. It protects receivership assets. The receiver has the ability and has been, relying on it. So, why wouldn't it be property of the receivership estate? And, Oregon has a statutory stay, like a bankruptcy stay. So we took the position and filed a motion with the court, basically enforcing the stay, saying this insurance policy, going through the process, right? And explaining to the court why we believed it was property of the state, and that the insurance company's, request and saying we're gonna terminate unless you do this, was a detriment to the estate, was altering property of the estate, and that was in violation of the stay. And we were successful. And the insurance ultimately got renewed after the court entered its order at the same rate that it was. So that was one of the first things we stepped into, not we stepped into, that occurred as I got involved. And that became a pretty big deal because we were able to save the estate approximately $2 million, and it was a pretty quick process. So that's kind of one of the things we had to deal with right in the beginning.
Yeah. So you've gotten through this initial hurdle, which, I mean, kudos, right? Insurance is something we all deal with as a challenge in receiverships for a variety of reasons. Change of ownership is one, but there are always a number of others that come up along the way. What else did you guys do as a part of this receivership?
Yeah, I mean, there was always the normal issues that you have at a property if there's a, an allegation or you're dealing with insurance coverage and stuff like that for, a slip and fall or whatever. Okay. So, that was on day to day. And, it's the usual stuff in a receivership, just in operations that come up and everything. But really it became the busiest part of the case was, as we got into the sale process. And really it was sold as more as a private sale. An auction was not held. There was not really a marketing process. A very, large and experienced operator in this space, was interested. So clearly there's a lot of negotiations going on when you're going to have a sale at less than the full secured debt. So certainly the plaintiffs/lenders involved, to make sure that they're going to consent and release their lien for the right consideration. And then also there's in any private sale in a receivership, making sure that the court has sufficient facts and the receiver is comfortable. And I'm sure when you wear your receiver hat, Eric, you're in this world. You need to be comfortable as a receiver that you can go to the court and stand before the judge and say, I believe this is the highest and best offer. This is why, in going through the process. So, that's part of it. And also making sure and I'm not discounting office or retail space, but as you noted, Eric, you're dealing with, patients and care. So, one of the most important things is you always want to make sure those patients are cared for at the highest level. And
Mhm.
if there's going to be any type of a sale or transition, to make sure you have continuity of care. And that was always that was the number one thing on the receiver's mind, to make sure that there were no hiccups or nothing happened that would adversely affect the patient care, which I think is right. That is the number one. And then, kind of going through the process of, being comfortable with the sale, being comfortable with the buyer, that the buyer, if they came in, can take this over, can provide good care, great care, etc., going forward. So that's kind of one of the parts, and you're dealing with that at the same time you're dealing with purchase and sale agreement, and then you're also negotiating a lot of the terms, as we all understand in a receiver sale, receiver is a quit claim or receiver's deed. There's no warranties. There's very little reps and warranties a receiver can give because you're an arm of the court and you take it over for just the property over for a period of time, not the company.
Yep.
So there's going through that process and sometimes explaining to the buy side and sometimes the title company. I
Mhm.
mean, I think title companies have gotten a lot better and now have special divisions to deal with these types of things. But going back 10, 15 years, that always wasn't the case, and getting comfortable with this process. And I think some of the standardized laws, especially, UCREA and others have really helped with that. But kind of going through that purchase and sale agreement process, the conveyance documents, working with all the interested parties, title company, plaintiff lender, borrower owners, buyer, etc., to go through that. But at the same time that we're doing that, we also had to look at the runway because I guess in the industry, what I learned is called chows and choms, chains of ownership, chains of management.
Mhm.
And those are two separate processes. And this new buyer, what I've learned, and I've done a lot of these, sold close to 60 senior living facilities over the past number of years. And what I've learned in this process is that there's kind of two ways to do it. Either you do the sale and you close the sale and the current operator kind of stays on under a bridge agreement or an indemnity agreement or whatever, where they either continue to run it or they, have an indemnity agreement where you come in and they supervise you running it while you're getting your license as the new buyer. The
Mhm.
other way, and the way we did it in this case was we kind of got everything solidified, got everything signed, subject to court approval, of course. And then the PSA, the deal was required by the state regulatory agency to then get the license.
Mhm.
And that process ranged between 60 and 90 days in Oregon. I think we signed up in May and we had our sale hearing in August. So right after the license was granted, they said they would approve it. We filed the sale motion. It was all on consent. The receiver and I flew to Oregon, stood before the judge, presented the motion, and the judge approved it. Part of that, there was also a rejection, assumption rejection process. Oregon had those laws, so we had to get the proper notices of what was being taken. So throughout that whole process, it was getting your arms around all the agreements, what is being taken, what is not being taken, making sure you have the right schedules, making sure the motion and the order deal with that. But then there was also the process of applying for and being inspected by the government for the license for things as little as making sure all the light bulbs are working, to is food service up to standards, how many people are there, what's the, when you look at the census of the facility, how many people are working, is it within the guidelines, talking to the executive director, looking at the automobiles that are part of it. All of these things, you have to go through this process. And that was sales and receiverships have another level of due diligence and scrutiny and legal anyway, just because of the nature of it. And luckily, there's a lot of us and members of CRA, you, et cetera, have done this and we understand it. But there's things and things come up. In distress situations, maybe you can't find all the contracts. That's never happened to you, right, Eric?
Oh gosh, no. I mean, everyone just, day one, they just show up and they just hand them over to us and they're like, "Is there anything else you need, sir?"
Yeah. Yeah. So sometimes you're building the puzzle and everything as well. But, we get through that. We get the order, had all the right consents, had everything there, filed a couple supplemental motions, assumption and rejection, and closed. And that was kind of the process. But it was a busy, probably 5, 6 months.
Yeah, it's a lot to pack into 5 or 6 months, especially. I know even just a lot of what you described reminds me a lot of our cannabis receiverships in that it's not necessarily called the same thing, but the chows and choms, like that you mentioned, you go
Hmm.
through that. Although in cannabis, at least in Missouri, you don't get anything back from the state in 60 to 90 days. They used to be about 3 years. Now they're down to about half a year. So,
Hmm.
so 60 or 90 days sounded pretty good to me. Uh,
Hmm.
yeah, like, I mean, it's just one of those things where, and I'm sure you do this too, where you kind of take your experience in one industry and you're like, okay, here's how I can use this in my future receivership case because even though it's a different industry, there's similarities between how things operate. Can you kind of talk about some of those lessons that you learned as you went through this case and kind of as you dove into the senior care facilities?
Sure, sure. And this was one of my first cases in this area. I think it was my first case in this area. So, we had, luckily being at a full service, national law firm, I had a colleague who was licensed in Oregon, also for the other deal in Washington. So she was really heavily involved in everything, and she had experience in real estate and environmental and stuff like that, so regulations and everything. And I also brought in members of our healthcare team to help with that process, especially in the PSA with any of the special healthcare procedures or looking at due diligence or the license process. I'm not a healthcare lawyer, so I was really, really fortunate to have a great team here at the firm that helped me with the healthcare side. I had a great real estate team. You're dealing with 14 different properties, so 14 different conveyance documents, FERPTAs, affidavits, tax issues, etc. So I had a great team on my real estate side to help me with all of that as well. I think one of the lessons I've learned in this and really over the years is get the right people involved as early as possible.
Mhm.
Once you know you're going to have a title company, get them involved, get their senior underwriter, get the relationship person, get the senior underwriter who's going to be on the deal, and get the in-house counsel that's going to be on the deal. Get them involved as soon as possible. Make sure when the time is right, they're getting the PSA, they're getting the conveyance documents. We're getting bring downs on title. We're looking at the exceptions. Doing that as soon as you know this is going to be going to a sale process, whether private auction, online auction, whatever, get them involved now. Get any of the regulatory people involved as soon as you know now. Get their checklist. What are you going to need? Is the title company going to make us wait for the appeal period to run? Or what do we have to do to make the appeal period not to be able to close before it runs? Is that consents? Is that waivers? Is that there's no objections? What is it? And it varies. But that's one of the biggest lessons that I learned, especially in this type of deal, which has the healthcare and licensure level above that you're going to get in, let's say, like an office or an industrial or a retail. There's another level, and it's a very important level because you're also dealing with not just properties, people's lives and people's lives that need care. So making sure that that is all taken care of in the beginning, having the right team, talking to the right people, and talking to them early. Because the last thing that you want is you go through a whole process and you get a sale order and you go to the title company to close, and you're like, well, we're not going to close on this. You're going to start all over. It doesn't make you look good as counsel because it makes you, it doesn't like me look good as counsel because it makes it look like not what I don't know what I'm doing. So
Hmm.
that's never happened to me. I get the team together initially,
Yeah.
get the right people.
Well, the regulators are a good one too. I mean, sometimes they're hard to corral early on, but you've got to do it right.
Mhm.
Otherwise, coming to them after the fact and saying, "Hey, here's who's buying the business," and they're like, "Yeah, we're not going to approve a license to them," means you wasted a lot of time and probably will irritate a lot of people.
Exactly. And that was part of the initial due diligence too, Eric, when I was saying about looking at the buyer. This buyer was a sophisticated, large national entity that runs these facilities everywhere. That's probably a little easier than if you have somebody who's brand new to the industry.
Hmm.
And that's part of kind of the scrutiny because when you serve in your receiver hat, if you're standing before that judge who appointed you and who you report to and have fiduciary duties, can you say with a straight face, well, this is the highest and best and this is the best operator? If they're, I'm not saying they won't be if they're a new company. I'm not saying that at all. Everybody deserves a chance and there's a lot of people with experience, but it's like, what level of scrutiny have you gone through to be able to make that recommendation? Because let's face it, that judge is depending on you.
Yeah, and I always have to remind people that judge in Missouri is seeing a bunch of other cases that same day. Some of them are murder trials, some of them are
Mhm.
a lot different than maybe perhaps a small business fight. And so the judge is only going to have so much capacity for your hearing. And so you want to get in, you want to get out. One of the attorneys I work with regularly always says, easiest argument is going to win. Right. And so, if you can simplify it so that the judge goes, that makes sense, let's move forward. It just makes your life easier. It makes their life easier.
It's almost like a bullet point or check in the box. Make sure you walk the judge through it. Make sure you're prepared for questions. I remember when we were doing this sale hearing, one of the cases before us was a divorce. Then there
Hmm.
was a real estate dispute. Then there was a personal injury case. And
Hmm.
we come up with a property that's selling for tens and tens of millions of dollars. I think it might have even been over $100 million deal, maybe 110 if I'm not mistaken, for these 14. And it's like that's a whole different thing
Hmm.
and making sure, as you said, that you can walk the judge through it in a very straightforward, direct way, checking all the boxes that judge wants to hear, and being prepared to check the boxes that maybe you didn't know the judge wanted to hear. And that's preparation. And I can't
Hmm.
remember what it is, but they're saying about preparation, right? So that's what you need to do. And listen, I know sometimes people are like, it takes time and that takes cost and everything. I mean, I think, a lot of times, we're seeing a lot of receiverships because the bankruptcy process can be expensive as well. There's provisions for single asset real estate that the stay, can be lifted real quick. And, going through the receiver process, I think is an efficient and effective way to do it and understanding that and it puts more money back in the creditor's hands.
Hmm.
But if you don't do it right or you don't prepare and a hiccup comes up that you could have prevented, that's not good either because that's going to take more time and money. Do you lose the buyer? Do you have an outside date? And I think that's one of the things I would say in general of all the sales that I've done is looking through that PSA and putting together kind of the run of show of what the pertinent dates are going to be. You gotta leave yourself a long runway. Maybe you can say when you'll file the sale motion by, but I keep it as open-ended as possible because we don't know what the court dockets look like. We don't know what that's going to be. And judges are very busy, especially in a lot
Hmm.
of the state courts that these are held in, very busy. So you got
Hmm.
to be cognizant of that.
Yeah. Well, this is great advice. Is there anything you want to leave listeners with?
No, no, I appreciate being this. To the extent there's non-CRA members, this is the things that I'm talking about here. There are a plethora of professionals, both legal and business, legal, me, Eric, business, that do this across the country, do it in their geographic regions or nationally. So I guess if there's somebody who's newer to this and it's listening this, take a look at the CRA. And I know there's a lot of folks that are very open. Eric is, I am, and others in the group that you can always feel free to reach out to us, and we're happy to help because, we want to make sure that this is a process, this is, a practice that is providing benefit and value in sometimes very bad situations financially. So that's what I would leave. If there's somebody who's not in this industry and is thinking about getting into it or whatever, this is I tell everybody about this organization, and I would highly recommend being involved.
Well, thanks, Mark. I really appreciate your time today.
All right, Eric, thank you.
Thank you for joining Navigating Receiverships, brought to you by the Commercial Receivers Association. Find more information at commercialreceiver.org and catch every Navigating Receiverships podcast by subscribing through your favorite platform today.